And it's time for another edition of our bi-weekly, or I guess you'd say every other week program. Anyway, Attorney Ziona, and if you don't know how to say this, just listen to me carefully, Kopolovich is here for our Debt Relief Radio program from the Debt Relief Law Offices, which are located in Newport Richey. We'll tell you those phone numbers and all the other information you need to get a hold of Ziona and her staff for your help with your, mostly we're talking about bankruptcy and things like that. Ziona, welcome to the show.
Well, it's nice to be here. How are you doing?
I'm doing well.
Haven't seen you in 2 weeks.
Yeah, it's been exactly 2 weeks.
2 weeks, right. Is it okay if I give my phone number in the office?
Yeah, well, I said we're going to do that at the end, but we're going to do it right now, too.
Yeah, I'd like to do it now because Shannon is sitting there by the phone
waiting. Shannon's waiting by the phone. Right.
Yes. So the number is 727-849-3328.
Mm-hmm.
Okay, and we're located in Newport Richey, which is just a hop, jump, and a skip from
here. Especially if you take the Suncoast Expressway.
Absolutely.
You can get there in a hurry. I wonder, it is, your mic is making a noise, and I don't know why. I hope it's working well. We have a guest that she brought with her, Constance DeAngelis.
Yes, hello.
Good. How are you today?
I'm just wonderful. Thank you for asking.
Your mic's working fine, but it's making a weird thing on my little machine here, but that's okay. I wonder what that is. I can't hear it, but evidently it's there. Anyway, tell us, Ziona, about Constance so that everybody understands why you brought her with you.
Okay. Well, if you remember, I was talking in the past about relief that my clients get in through bankruptcy. So we file Chapter 7s to relieve people from basically mostly their unsecured debt. We file Chapter 13s to help homeowners, a lot of homeowners, when they're in trouble with their mortgages.
Right.
One of the ways that we help them is by modifying the mortgage, modifying the terms of the mortgage. Now, when you're sued in circuit court for a foreclosure, the court will send you to some kind of a mortgage mediation. Most of those really failed. It just, it takes time, and the homeowner ends up losing their home because nothing changes. But under the auspices of the bankruptcy court, we have been able to modify mortgages in a meaningful way and give people in trouble, we give them a solution to a painful problem.
Mm-hmm.
Now, Constance is a mediator.
She's a mediator.
Yes, and I had the pleasure
a real live mediator.
A real live mediator, and she's
with
very
a pulse and everything.
Yes, I can see that. Yeah,
and she basically guides the parties to come together to a conclusion that is, in most cases, very satisfying to what I care about. It's most satisfying for my clients.
Well, of course.
So with that, I will let Constance explain to you and the audience what she does and how she's able to help the process along.
Well, first I'd like to know, Constance, how do you get to be a mediator?
Well, that's an interesting question.
Is that a tough question?
All right. I'm also an attorney.
Okay, so you're an attorney.
But you don't have to be an attorney in Florida to be a mediator.
Okay.
In Florida, there's a certification process through the Florida Supreme Court that certifies mediators in a lot of different areas. One of those is called Circuit Civil. Circuit Civil is the state court that handles things like foreclosures and business litigation and those types of things. So I happen to be a Florida Supreme Court certified Circuit Civil mediator.
Oh, right now.
Say that one with not taking a breath. And in that process, we have to take a 40-hour course, and then we have to do a type of internship where we view and also co-mediate disputes. The situation with respect to the mortgage modifications is a real unique situation, and those of us who are involved in that one, that type of mediation, usually will have special training. Now, the Florida Supreme Court had put out an administrative order that said you have to take certain training. That has been rescinded, but the U.S. Bankruptcy Court, and here in the Middle District of Florida, which is one of the divisions, there are 3 divisions in Florida: Northern, Middle, and Southern. We're in the middle. And in this division, an order has just come out that says any mediator who is a circuit civil Florida Supreme Court mediator, I hope I'm making that, speaking slowly
I'm
enough.
You so far.
All right,
Yeah.
also has to have an 8-hour course in the areas of loss mitigation, mortgage foreclosure, and bankruptcy. Because then that mediator will be able to bring the parties together and hopefully facilitate a win-win solution for both the creditor, which would be the mortgage holder, lender, servicer, plaintiff, and then the debtor or the borrower whose homestead is at risk. So that's what we do in, right now, Chapter 13, which is it's like a wage earners reorganization, where part of the debt is paid, and there are a lot of benefits for the homeowner with respect to how to structure their debt regarding their home mortgage. So then what we do is we as mediators are like facilitators. The court orders that the homeowner, borrower, and the creditor must get together and discuss the possibility that a modification could be granted to the homeowner, which would reduce the cost of the homeowner's mortgage payment every month. This can be done through government programs. There's also a Department of Justice settlement situation that has just happened within the last, say, 6-8 months, where some homeowners could actually qualify, or the servicer or lender could have a proprietary or an in-house type of modification. So the rule of thumb is that you take the gross income of the homeowner, the borrower, times 31%, and that amount is considered to be an affordable payment. So that's where we start.
You take the gross income times 31% of the gross income.
Right.
Gross meaning before taxes?
Before taxes and everything. Now, there's some nuances here.
That, I might add, should include not only the mortgage payment, it should include interest, it should include homeowners association fees.
As we call it, PITI, principal, interest, taxes, and insurance, and homeowners fees if needed. That's the 31%.
That's the 31%.
Right. And we have
Wonder how we came up with 31%.
That would be a governmental review under the Home Affordable Program.
That's interesting,
that they
31%.
call HAMP.
Yeah.
But that is considered right now affordable. And therefore, people can begin to look at what their gross income is. And when they take 31% of that, see whether or not it's possible to modify the mortgage and the monthly payment reach that 31%. Now, there's a lot of different ways to do that, but that's where we begin. And what's really important here is that because the bankruptcy court is so aware of and understands these programs so well, that when the court issues an order, what I have found, and I've done mediations in the state court and also in the federal court, of course, is what we're talking about here. The creditors seem to be able to put the right people in place to be able to appear at the mediation and be very cooperative. And we are
More
finding
so in bankruptcy court.
more so in bankruptcy court. Recently, and this is something that happened with Siona, I was a mediator in a case. We met a number of times, and we were, everyone finally got on the right playing field, and we were able to have the creditor offered a principal reduction in the amount of the debt and provided a payment that reached that 31% we're talking about. And of course, the borrower is elated. And now the creditor has a performing loan. So it's a win-win for everybody.
Yeah, let me remind you, if you remember, about a couple of weeks ago, I mentioned that we had a successful mediation.
Right. Mm-hmm.
And if you remember, we got the mortgage holder to bring the principal balance from $170,000 down to $110,000. Forgave 2 years of arrears. That is huge.
And all of that was to reach that 31%.
To reach the 31 and reduce the interest rate to 2%.
Mm-hmm. And that went into, you had to reduce it that low to get to the 31%?
For the
Everything
equation
is based
to work.
on working to that number, to that magic
Usually,
number. Yeah.
right around that number. There are some programs like the HAMP Tier 2 that deals with things a little bit differently, but to get into all of those nuances, we probably need a little more time. There are a lot of different programs out there. We're talking now about a general homeowners program, but there are many other programs out there that in some cases might deal with even rental properties, and some might have rates. The lowest rate we've seen is 2%, or even as we have debt-to-income ratio issues. I don't think we ought to get into some of those real heavy nuances. It gets too complicated.
And I'll fall over, and that won't be funny.
Your eyes will glaze over.
I'll glaze over and just go right to the floor, and that won't look good. But it's all very interesting to me, and this probably is an inappropriate question, but that 31%, or somewhere right around there, is probably something people should look at when they're thinking about buying a home.
If you remember years ago when you went to take out a loan to buy a new home, the bank wouldn't approve a loan over 25% of your gross income. These were the old figures when banks were more conservative, and somehow we have gotten away from it, and the public is paying. I mean, paying in more ways than one by losing homes because people simply overextended themselves in taking out loans, and the bank allowed loans that now they won't do.
We have 10 minutes left. And by the way, if you want to call with a question, you can, 796-7272, or you could use 277-5919, or you can call from anywhere on the Nature Coast toll free at 1-888-613-2050. And I'm sure Constance or Ziona will be glad to help you with it. Anything about this, because this is very interesting to me. Because it seems to me you walk into, and so you all get together at a mediation. So where to be, at your office?
Well, most
Generally?
of the mediations are in Tampa.
Yeah.
The federal court, the U.S. Bankruptcy Court, is located in Tampa.
Right.
And so that's usually where we hold them. Although we can hold them in Newport Richey or Dade City
Wherever.
or
You can hold them
other
there.
places, but usually in Tampa. And we meet in a conference room, an office, and usually the borrower, and if there's more than one borrower.
That's what I want to do. I want to kind of go through it.
Right.
So we walk in the room, we all sit down, and then what happens?
Okay, so, well, it's a little different from we all walk in the room and sit down. The borrower and the borrower's attorney will usually appear in person.
Mm-hmm.
And it could be more than one borrower, of course. We could have husband and wife or something like that.
Sure.
So we might have, and then sometimes they might have another person appear with them as well, and usually that's okay. Okay? Then what happens is the creditor usually appears by telephone because these creditors and servicers are located all over the country.
Right. We talked about that last week, or 2 weeks ago.
And they're
how
on
unfair that is. I think they should have to be there. But anyway, that's another story. Anyway, so they're on the telephone.
And very often the creditor's attorney will appear in person, but it is possible in the bankruptcy court for the creditor's attorney to also appear by telephone. Therefore, then we have them on speakerphone. Now, in the state court, that's usually not allowed. In the state court, the attorney for the creditor, well, known as the plaintiff or servicer, usually appears in person. In the bankruptcy court, they are allowed, as long as we agree, to appear by telephone. What happens then is we conference them in on a speaker phone, and one of the key points about mediation is it's confidential. What is said the days of mediation when we have opened a conference cannot be brought out in court. There can be no subpoena, for example, for me as a mediator to come into court to talk about what a borrower said or what a creditor said.
So what is said in that room stays in that room.
Stays.
Sort of like Las Vegas.
Right.
Yeah.
But
it can't be used.
it cannot be used.
In other words, if you don't come to an agreement and the thing goes to court, you can't use any of the information imparted in that room.
But the lender told me, blah, blah, blah. You cannot do that.
Exactly.
Do you think that's a good idea?
I think it's a great idea.
Because it really opens up the channels of communication better?
It absolutely, it becomes a lot more of a cooperative circumstance.
I see.
Because I'm a facilitator. The mediator is a facilitator. This is what they call, and this is written even in the mediation rules, self-determination process, which means that the people who are in that room that have a dispute, and the dispute happens to be default on a mortgage loan and the possibility of modification of that loan, that dispute then is allowed to be brought to the surface where nobody can talk about the issues that come up there. They can bare their soul or whatever happens to happen there. The numbers can be brought out. Numbers, I mean the amount of the debt and the amount that's due and what the interest rates are and any of the programs that are available to this borrower, and all that can be brought out right there. And then the parties make the decision. There's a big difference between being a mediation and an arbitration. An arbitration, and I do arbitrations for the financial industry too, but that's where the arbitrator is like a judge. And the judge makes a decision. Okay, you win, you lose. There's no win, no lose here.
You don't do that.
This is self-determination between the parties. Can they make a deal?
And it is a win-win situation because in most cases the homeowner gets to keep the home with payments that they can make, and the bank has a performing loan, which that loan was not performing for the last 2 or 3 years.
Yeah, so it was worthless, is what it was.
It was a worthless loan, right. And now it has value. So it is a win-win situation. We keep people happy in their homes, and we keep the banks happy.
That's very, very interesting. Now, I'm trying to figure out how it works. So when would you step in? I mean, if the lender will make some offer.
No, actually, I, as the attorney,
You will
I have
make the
to
offer.
I have to file a motion to refer the case to mediation.
Okay, I'm talking about after we're in the mediation.
Once we're in mediation, she's there. She's
Right.
part of the mediation.
Once
so
we-
who speaks first is what I'm saying. Is
Okay, I would.
She guides the conversation.
Right. As a facilitator, the mediator would guide the conversation. But here's another thing that I think is important for people to understand. When the banks or lenders or servicers, however you want to put it, because they're all different.
Sure.
When the entity that's responsible for taking care of the loan gets the mediation order, they then provide a possibility of review of documentation from the debtor or borrower. It is incumbent upon the borrower to prepare extensive documentation regarding their financial situation.
Sure.
And I mean, sometimes this could be as many as 50 pages. And that information, is extensive. And it is transmitted to the creditor. The creditor then reviews that information prior to the actual mediation conference. So there's a lot going on before we all get together in that room. When we are together in that room, whether there's telephone and personal appearances or not, then the mediator starts by explaining the confidentiality rules.
And does that information that you've provided on behalf of your client, that financial information, is that also restricted as to its use? I mean, you can't bring that to the courtroom if it fails?
That information is basically public knowledge.
Okay.
I mean,
All right.
we know what the mortgage
I'm just
is.
trying
We
to
know
make
the
sure
mortgage
I understand
payments
that. Yeah,
are.
okay. So it can be used in the courtroom.
Well,
That
it can be, but
information.
not in that form. And the reason we
Yeah.
say that is, for example, in a Chapter 13 bankruptcy, the debtor or borrower have to file extensive, I used that word a couple times, schedules that indicate
Yeah.
their financial condition. All right, well, they've already filed that. That's public knowledge. So it's the way that information then is put into form regarding their mortgage modification process. That information cannot be used in
the
that
court.
form, but all of the information that gives rise to it, such as tax returns and financial data, maybe a profit and loss statement, that's obviously available on other contexts.
Because we only have 2 minutes left. I want to make sure a lot of stuff gets in. So you would, make an offer? Ziona, would you guys make the first
pretty
offer,
much the
or
program.
they would make the offer?
The program is ready. I mean, we go by the guidelines. The client will either fit into the guidelines or will not fit into the guidelines. And if it doesn't fit into, let's say, the HAMP program, they may fit into the HAMP Tier 2. If not into that, there are programs that the bank may have, an in-house program that they may fit. So the programs are preset, and you simply have to fit into that program. So here comes the attorney helping the client to be able to fit into the four corners of the program, because the bank is limited by the rules that are
and so
promulgated by Congress.
you're trying to get them to fit? Is that
Yes,
is that
and what
you're
happened,
doing?
the mediator doesn't attempt to get them to fit,
Yeah.
but the debtor's counsel does. That's why it's so good to have good debtor's counsel, good borrower counsel, because they know what these programs are. Now, I know what the programs are too, and if
Well, sure.
I mean, we
And
can
she
go
knows
ahead
what they
and
are.
right. So what's important is that the people who are involved know what the programs are, knowing then, so that we don't have any unrealistic expectations. The debtor's counsel can tell their client, look, you're not going to, it's not going to work here, or it is going to work, and this is why. And those are assessments that are done by debtor's counsel when they first meet their client.
Well, listen, I wish we could go further, but I want to do Constance DeAngelis is the mediator. And thank you for bringing her, Ziona. Of course, Ziona with Debt Relief Law Offices of Tampa Bay, 5422 Trouble Creek Road, Newport Richey. But here's the phone number, the important part. The phone number, 727-849-3328. She also has all kinds of, what do you call them, email addresses, bankruptcytampabay.com.
That is the website,
That's the website.
bankruptcytampabay.com.
And the, what is it, assistance at Debt Relief Tampa Bay.
Assist.
at Debt Relief.
This is
Tampa
the email,
Bay.
assist at debtrelieftampabay.com.
Okay, thank you both.
You're welcome.
Pleasure. It's our pleasure. Thank you.